today is about the basics of business contracts with our presenter, Marcy Smorey-Giger. And Marcy, you can go to the next slide. For those of you who may not know, this organization that is presenting this program is Entrepreneurs Forever, and our mission is to empower all small business owners to grow thriving businesses that sustain their families and support their communities. If you're not already a member, you want to learn more, please circle back to us. We'd love to hear from you. We run peer groups, and Greg Russack is on the call with us. Greg is one of our facilitators, as am I. These groups are wonderful for our folks, and we'd love to have you. All right, next slide. I did not used to do this, but I now make sure I mention upcoming events before we actually get into this program, because I never remembered to come back and do it at the end. So we have a very good special program with April Jackson of CapJ Consulting. If you have ever thought you might have imposter syndrome and had trouble sort of getting over yourself and owning your success, this is going to be a terrific new and special program one time on Friday, June 13th at 8:30 in the morning. Own Your Success. That one's going to be limited to 30 people. And then our next regular deep dive on Monday, June 16th is Getting Found Online in the Age of AI. And if you don't know what I'm talking about, I challenge you to go do a Google search and see how hard it is to have a business come up in the results, because Google is intermediating the results, and it's not as easy as it used to come up in the search results. So we have a program next month that's going to help you think about that. So you can register for all of our events on our website. Okay, Marcy. Wow, this is the most detailed disclaimer we've ever had to do. Guess who supplied the words for it? That would be Marcy. Do you think we need to read it, or is it showing it enough?
This is sufficient.
Okay, here's the thing. We are offering you this free information, but it does not take the place of a real lawyer who you pay to get paid advice from. Read the disclaimer. Okay. And now you're not going to have to hear me anymore. You're going to hear Marcy, our guest presenter. I've worked with lots of presenters. You guys know I do these programs every month, and it's been such a pleasure to work with you, Marcy. And I have to tell you, there's a stereotype. Oh, it's going to be boring. It's all this law stuff. We've had fun working on this and trying to create a presentation that we thought would be really relevant for you guys. So welcome, Marcy. And I'm going to shut up other than sort of monitoring the chat and helping make sure the conversation goes the way it should. But otherwise, you are on.
Thank you so much, Deborah. I'm really pleased to be here and pleased to have an opportunity to talk to fellow entrepreneurs. It's a place that's very near and dear to my heart. I grew up small business. My parents were self-employed from before I was born to the day they retired. And while I had a chance to go out and be in corporate America for a while, I was thrilled and am now truly rewarded to circle back and help small business owners. So my firm, Smorey-Giger Law, that's what I do on a day-to-day basis. I help small business owners with pretty much all of their general business legal needs. So the whole life cycle of a business, from when it's founded to when the end is approaching, whether that's handing off to the next generation or selling or dissolving. I get the privilege of helping those business owners along that entire path. And for about 2 decades or so being in-house, I really learned what a corporation needs from its lawyer to make sure the business is successful. So a good example of when I see that on a daily basis is just general commercial transactions, which is blanketed with contract law. So it's a perfect segue for me to talk about our key topic for today. But one last thing I'll mention to you, because it is kind of relevant, is in addition to my law practice, I also teach at Pitt Law and Duquesne Law, both here in the Pittsburgh area. So I embrace opportunities to educate. I see that, of course, with my students. I see that with my clients. But today, I embrace the opportunity to do that with you as entrepreneurs. Oops. So a few minutes ago, Deborah mentioned the disclaimer slide, and I do think it's pertinent for me to just touch on that briefly, to emphasize the fact that this really is educational. So there is lots of really good information here. There's a lot of general information here, but it does not entail legal advice, right? That's limited to when there's a true attorney-client relationship. And that's not applicable today, but I find myself in a privileged situation to be able to help my clients with these kinds of things every day. So I'm hoping that some of these tips will be really, really helpful to you. So what all are we going to cover? I appreciate that an entrepreneur always involves themselves with innovative things. They're bringing very valuable things to market, embracing new ventures. And so that inherently involves taking on risk. And there's an understanding that the fundamentals of contracts is, in fact, one of the best ways that you can use in your favor to reduce risk and therefore really protect your business. So as we learn, what a contract is, the key elements that make it valid, the types of contracts you might encounter, you can hopefully then make much smarter decisions and avoid really costly mistakes. So knowing when contracts should come into play, recognizing these common clauses, being aware of the pitfalls, we're going to give you some key points to keep in mind. I think that's really going to help you protect yourselves and make your business that much more successful. So we're going to review practical tips. We're going to talk about drafting contracts, when to do it on your own, when to get help, how you can really confidently sort of approach all of these topics to safeguard your interests and keep your business on solid ground. So we're going to go through what is a contract. We're going to go through the elements of a valid contract, the types of business contracts you're most likely to encounter. It's not a complete list, but it's most common. We're going to say, what should be on your radar. We're going to review common clauses that are typically available in just about every business contract. We're going to also go through some pitfalls that are very common and how to avoid them, some practical tips for reviewing and drafting contracts. And then, as Deborah mentioned, we're going to have a nice opportunity for Q&A at the end. So that being said, let's talk a little bit about why this is a whole hour of your time, right? Why are we spending some time here? Understanding business contracts is, in my opinion, very critical to the success of your enterprise, because those are the commercial agreements that exist between you and all of the other key business parties that you have. And if you use them to your benefit, they protect your interests and they help your business run smoothly. This knowledge not only prevents, what could be really costly disputes for if there's legal issues that arise, but on a more promising end, it builds trust with the people you do business with. It supports strong relationships, strong partnerships, and contracts can really create a foundation for financial stability and growth. So why understanding business contracts is essential for you as a business owner? You got to use those contracts as truly that foundation for that professional relationship, right? It clearly defines rights, it clearly defines responsibilities, and it sets the expectation between the parties, right? You avoid misunderstandings when it's all written there and you all have the same expectations. So a well-drafted contract ensures that everybody that's involved understands their obligations. It reduces those misunderstandings, and hopefully in that process, it's going to really avoid potential disputes, which we know is going to save you a lot of money with unnecessary lawyers and litigation. In addition to that, you can use the contracts to enable some extra legal protections for yourself, help to mitigate risk within your business. Certainly secure payments with your customers, right? You want to get paid on time, you want to get paid fully. Contracts can help you secure those payments. And invoice, and in addition to that, it can also enforce whatever your rights are in the event there is some sort of breach of that contract. If you don't have this really strong grasp of contract terms and these principles, then that type of scenario could cause that business to face, financial losses, possibly injury to your reputation, legal complications, right? The list of things that could go sideways grows if you don't give enough attention to legal contracts. So real world implications, right? Avoiding legal disputes, right? Contracts can really help prevent costly and time consuming legal battles because you've set those really clear expectations. A well written contract outlines if you do have a dispute, how does it get resolved, right? So what's the mechanism for dispute resolution, such as are we going to go straight to court and litigate, or is the contract prescribing some alternative like mediation or arbitration? Those contract dispute provisions help the parties to hopefully resolve disagreements without getting to extremes and causing everybody's a lot of stress and a lot of expense and a lot of business disruption. Other real world implications is, if you don't have those really precise terms in your contracts, those ambiguities can lead to conflicts, again, straining your business, negatively impacting relationships and operations. Ensuring compliance can be a key part of this, right? That business contract could make sure that all the parties that sign it, especially those performing, providing services or providing products, that their actions align with local laws, state laws, federal laws, right? We don't want anyone to get penalized inappropriately because someone else didn't hold up their end of the contract. If it's well written, then non-compliance with tax laws or labor laws or consumer protection statutes, even industry specific guidelines, those things could result in fines, lawsuits, even, really consequential things like shutting down your business. If you start to get into food and restaurant supply, health codes, who's responsible for what. We want all of these contractual obligations to be well understood, helping those companies to stay within the legal boundaries, and have really strong ethical business practices. Another real world implication would be just your asset protection, right? Your business interests and the assets that your business has. You want to safeguard those, right? All of these critical elements that are crucial for your enterprise, we want to make sure that they are protected. Trade secrets, intellectual property, certainly your financial interests. So having that well-structured agreement, it's going to ensure that that proprietary information and those both intangible and tangible assets are properly protected, right? So we're going to make sure those resources don't get misused, abused, or damaged. So having a very secure, financially stable and performing contract, right, is going to enforce the fact that you get to have all of these protections built in that function. Plus, anything you might need to do to enforce payments or minimize risk because the other party didn't do their part under the contract. I'll also mention, and I touched on this briefly, about trust and credibility, right? So I think that having really clear contracts shows professionalism, right? It shows your business is legit. It shows that you take an interest in this and that you are approaching things from a very professional standpoint. I believe that builds trust with your clients. I think your suppliers will see you as a little bit more sophisticated. Those you go into partnership will know that you're truly paying attention to these important details. And trust is essential for really strong long-term relationships. Fostering collaboration, growing your business, you need trust with those other parties. So that well-structured contract is going to demonstrate your business is serious about what it's doing, it's responsible, and it's committed. And that'll also set the groundwork for some really fair business practices. Um, I think contracts also will facilitate negotiations. It'll facilitate strong partnerships, right? So you have now, with a good contract, a structured framework for discussions. It allows the parties to then be able to know exactly what they're focusing on and appreciate that they've got mutual interests here. They're going to be well defined in the contract, and therefore the parties now are very closely aligned because you have set goals, you have expectations, the deliverables are clear, so you have a really nice place that you can go to be kind of united and have the ability to strengthen that business partnership because you have clarity about that contract. And of course, good contracts are in all those strong relationships are going to, improve your financial health, right? So strong payment terms, ensuring predictable cash flow because you can rely on those contracts is going to give you that financial security that your business needs. And then, if you reduce uncertainties associated with those similar financial principles, then you can perhaps use those contracts for investment purposes. You can see the future that's coming in those committed contracts and expand. You can create new opportunities because you can rely on those new adventures can rely on the structure that's built in those contracts that are already in place. Again, contributing to your business growth and long-term success. So let's get down to the basics, right? So now we know why we're talking about this and the purpose of all of this attention. But let's talk about sort of the basics of a contract, beginning with the understanding that this is a legally binding agreement between two or more parties, right? So entrepreneurs like yourself, we really need to understand contracts because they do establish those expectations, going to protect against the risks, build the trust that's essential for focusing on our future business and securing those relationships. So some of the very common types of business contracts would be a sales contract. And you could be on either side of this, right? You could be receiving the sale of goods and services, or you could be on the selling side of products and services. The service agreement might be distinguished from a sales contract if it's only performance of services and not connected to any goods. Another common contract would be a non-disclosure agreement. This would include confidentiality provisions, commonly referred to as an NDA, a lease agreement. If you're in the business of actually leasing out residential space or commercial space, you would be the landlord. If you're the tenant, commercial lease agreements are a really common source of pure contract law, right? There's no statutes to protect the tenants in a commercial contract. You got to go with what's written in that contract. So key to look at all of those provisions when you're renting commercial space. So leases are a really good example of a commercial contract. And the last one on this list would be employment contracts, right? So if there's a written agreement between you and your employees, then that would be a place where you're going to find more about that relationship and how you do business together. So that's a great segue to talk about relationship contracts, right? So the contracts with key people inside your business. Entrepreneurs, we key other people that we do business with, key relationships are incredibly valuable, and we want to maintain them in a strong position. So entrepreneurs need contracts with those key partners, or key people like partners, suppliers, customers, employees. Having those expectations clearly defined in that contract is going to protect all of the parties, and because you want those relationships to be strong. Your business is as strong as those you do business with. So this is going to be helpful to make sure you have all interests protected, avoid misunderstandings, and also if the contract isn't honored, then you have legal recourse because it's going to be spelled out in that contract. So let's talk first about the people that you do business with that is in partnership with you, right? So co-owners, partners, or others that are kind of in a relationship inside your enterprise. So, where you would need to clarify ownership rights, you might need to clarify profit sharing or other responsibilities. So, those agreements, which could be partnership agreements, they could be shareholder agreements. Another common example is if you're in an LLC, a limited liability company, you might have an operating agreement. So those types of contracts are essential for defining ownership stakes. They give some perhaps the specifics on decision-making authority. They might have detailed descriptions about financial distributions, but they would give you a chance to outline responsibilities between you and those fellow owners. So I think that these types of agreements should be prepared early in the relationship, maybe even before you truly get into business together, because
Marcia,
things
I
are
want to confirm what you're saying because so many of our entrepreneurs work with an old friend or a family member. And if you can set the terms and expectations when you're just starting and you're friendly and foresee what the possible permutations might be in the future, it will make for a much smoother operating relationship and expectation setting from the beginning. Even if it's not a fancy contract, it doesn't have to have all those sub clauses and, be everything. It needs to be written down and everyone needs to agree to it. Greg's also
absolutely.
nodding. He's probably seeing this too. Yeah.
Absolutely, I couldn't agree more. And with even extra emphasis on the fact that having these written agreements prepared before things are rocky, right? Because then you're unlikely to agree. So that when things are smooth sailing early on, have some of this written out because it's going to provide you guidance later when you really need it. So here's a good example. So if you have a business, you've got two owners. And it's very common here in Pennsylvania to have a limited liability company with two owners. Creates great protection for your personal assets. Super smart to do. But that operating agreement, because you've agreed to go into business 50-50, right? You don't necessarily know without writing it, which is what I recommend. What do you do when you have a dispute or a disagreement? You don't agree what that decision result should be, right? But you're sharing 50-50. So how do you handle a tiebreaker? Or as time goes on, you might have a scenario where one co-owner contributes more capital, or one co-owner is more active in the daily operations, right? These things can start to create kind of fractures in the relationship, and you need some place to go to seek resolution. Disagreements can really stall a business. You can really harm relationships. So a well-drafted contract, prepared when all is smooth, is really going to give you guidance when disputes arise. Okay, so let's move on to another key section of contracts that are imperative for relationships in your business, and that's going to be vendors and suppliers, right? So you need to ensure delivery of good quality goods and services, right? And you need that to be under agreed terms. So contracts helping your business secure these necessary goods and services without, unexpected delays or unexpected costs. You don't want shortages. You need it to be in written contract which you can rely on. So supplier agreements are going to define pricing, quality standards, delivery schedules, payment terms. Any sort of vendor contract is going to give you presumably some remedies in the event that there's non-compliance, such as penalties for late deliveries, or what do you do if a product is defective. So again, you can really use those contracts to your benefit if it's written out in a way that you've got remedy if something goes wrong.
I could also point out that if you get a customer contract, it could open other doors. The one I'm thinking of is that I know somebody who got a rather substantial business loan on the fact that he needed this piece of equipment to take on these 10 contracts. And each of the contracts said, you can lay my new driveway for me, but he didn't have the equipment. But with the 10 commitments, somebody was willing to loan him the money because they could see that that was coming up. So anything that you can get in writing that will be to the benefit, you should do. And we should keep going because we have so much to cover.
Okay. You mentioned contracts. So let's just skip to the last group that is relative to key people and relationships, and that's the employees, right? Defining roles that the employees play, right? Everybody should know clearly what their job duties are, what their role is, what their authorities are, salaries, of course, benefits, of course, any sort of other expectations. If an employee has it in writing, then you avoid misunderstandings. So you've got to establish, exactly what with that outline of, salary structure, benefits, job responsibilities, what could cause termination, and you're going to reduce misunderstandings and disputes as a result. You might also add extra to those employment contracts like confidentiality clauses or non-solicitation. You don't want that employee when they leave to become someone who takes business away from you. You want to protect the company's proprietary information, market position, etc. Okay, so let's move on to talk about these transactions, right? So understanding the role that the contract plays is truly vital for entrepreneurs to create transparent agreements that protect your interests, reduce those potential conflicts, and promote what we all know is critical: reliable, long-term business relationships. So establishing clear expectations, right? You've got to define the terms and conditions for that business relationship, outline each party's key rights, responsibilities, obligations. This clarity, again, is going to prevent misunderstandings and ensure that you do business very smoothly, which gives you all of those perks, right? Also, a good contract is going to give you the legal protections when things aren't so good. So, a well drafted contract is going to give you safeguards built in, protecting your business from breaches, protecting you from fraud, hopefully avoiding dispute. If a party does not meet their expectations, if they fail to fulfill their obligations, then the contract is going to give you the grounds to enforce it, right? It's going to basically then lay out the one party's breached, and here's what the other party gets to do about it. Because you have included these, kind of approaches to building contracts, you of course are going to minimize risks and liabilities. It's going to help you to know exactly, what protections and remedies are built in, such as indemnifications, limitations on liabilities, dispute resolution. I'm going to talk about those three categories again in just a couple of minutes, but I mention them now because they are so critical in reducing your liabilities and minimizing risks. The last thing that I'll mention here, well, actually, I have two more. The next is enhancing credibility and trust, right? So these formal contracts demonstrate your professionalism. They demonstrate you're reliable. They give you that kind of commitment to ethical business because it's all spelled out and clear. Everybody's on the same page. And then the last one is that support to the operational and financial stability of your business, because now you have this visibility to revenue streams. You have a very clear, distinct payment terms, delivery obligations. So you can use these contracts as resources, right? Ensuring the other people you do business with, your stakeholders, your suppliers, that you have, kind of these structured agreements and giving a strong understanding, which is going to be critical for your business's success. So strong, legally sound relationships, are going to go hand in hand. So let's get into some of those key elements that you're going to see in a strong contract. So this is a little like heavy legal 101, but I think it helps once we start to really appreciate when a contract becomes enforceable. You've got to know the elements to know whether you can be bound or hold another party to be bound by a contract. The first element is offer and acceptance. So one party makes an offer, the other party accepts under agreed terms. This is when a proposal is suggested by one party and the other either behaves in a way that indicates acceptance or actually indicates acceptance verbally, right? So both elements must align to have a valid contract to form. Simply put, seller offers a service at a specific price, the customer agrees, right? Here's a more precise example. We all, in our entrepreneur lives, deal with some level of marketing, right? So, marketing agency offers you a social media management service. They want $1,000 a month. You agree to pay. That is a binding contract. You don't necessarily have to say the words, I agree to this contract. Acceptance can be as simple as making a payment, or acceptance on the other side for the marketing company can be as simple as performing the work. The behavior can be indicative of the acceptance, and therefore you have that first element. The second element is the value piece. This is, by legal definition, the consideration. It's the value exchanged: money, goods, services, right? Each party is providing the other in exchange to fulfill the contract. Both sides have to receive something of value. So, a really common example in a vendor agreement would be they supply goods in exchange for payment, right? They deliver 100 units of a product to a retailer. The retailer pays, $5,000. That's enough to fulfill mutual consideration. The next element is intention to create. This is what we refer to as a meeting of the minds. Both parties genuinely intend to enter into a legally binding agreement, right? And this mutual understanding and their implied or inherent consent is critical to forming a valid contract. There has to be that intent there in order to be meeting this element of a meeting of the mind. So a good example is two companies sign a written agreement outlining a particular delivery schedule and payment, right? So because they both signed, they both clearly intend, um, oops, they both clearly intend to be a part of this contract. I think, let's see, make sure I've got this next concept. Okay, capacity and consent. This is just basic. They've got to be of sufficient age past being a minor. They have to be an adult, and they have to have mental competence, right? And no misrepresentations, no duress, no undue influence. The last piece here is legal purpose. And this is also pretty clear, right? No illegal activities, right? If you've got a contract that is related to illegal goods or illegal services, it's not enforceable. So, not going to spend any more time on that. Let's move on to the types of contracts, right? So, we're going to talk briefly about contracts that are oral or verbal only, and also written contracts. We are in our entrepreneur world, we are moving fast, right? We are maybe wearing many hats, and we need to keep our business moving. So sometimes we're forced to rely on some informal agreements, but we need to understand the difference between written and verbal contracts, and where it's really critical, right? Especially when we have the need for precise clarity and enforceability might be at stakes. So, in a verbal contract, they are in fact enforceable, but it's just way harder because you don't have anything to point to, right? It's a valid agreement made through spoken communication, and it's legally binding if, in fact, you have all those elements I just mentioned, right? Those 5 elements I mentioned before, right? The offer, acceptance, consideration, all of those things. If those elements are present, then you do have a contract. However, the challenge is that while the contract's valid, you can have disputes because no one's clear on the specific details, because the difficulty is that you've got nothing to point to. You might go to try and enforce it. Even if you get to court and you try to enforce the contract, which exists because you had those elements, the difficulty is that you don't have that written proof and you don't have anything that is going to combat another party's perspective. So you have a phone call. This is a real life example, right? You have a phone call, and you and the other party agree that you're gonna, take care of this contract need by providing a service at a certain price. But later, you might experience a dispute over the price. Everybody remembers it differently. That contract is enforceable, but it's difficult to enforce on its specifics, such as price, if it was never put in writing. A little helpful tip, if you find yourself in that scenario where you had that phone call and you reached agreement, send a follow-up email. Say, hey, it was great talking to you. I'm so glad we settled on A, B, C, and D. That way, you now have something in writing to point to enforce that contract.
So it's not as good as an actual written contract, but getting the terms down in even in an informal email that you would send to them documents it, right?
Right.
Okay.
You're right. A true written contract that everybody, kind of formalizes is ideal. But if you don't get that far, the minimum I would say would be to try to recite what you did agree to in some written communication that everybody receives, so that you have something to go back to.
Great, thank you.
Okay, so the written contract, right? This is definitely the preferred form because it gives you that clarity, it gives you that written proof, and it gives clear documentation that what the agreed terms are. So you avoid that ambiguity, you avoid that misunderstanding. So the big perk here is that now you have legal proof in the event of a dispute. You can refer to the exact language in the contract. So it's going to reduce those risks. It's going to set clear expectations. And most importantly, it will be comprehensive and enforceable because you're going to rely on it for all the reasons we mentioned earlier, right? The reason why you have contracts to begin with in your business is so that you can have, payments received, deadlines met, schedules adhered to, et cetera, et cetera. So here's a great example when a written contract is truly valuable for entrepreneurs. So many small businesses don't have, full-time large staffs, and they might need supplemental or periodic help in the form of non-employee workers, right? So independent contractors who receive 1099s and don't get put on true W-2 salaries. Having a written contract with those individuals will make it very clear what their duties are, what your expectations are for when they deliver their work, they provide their services, how you pay them. Anything you need them to do is going to be in a contract because they're kind of like a little mini vendor to you. But even beyond the services, is how do you protect yourself so that they aren't deemed an employee, right? They have to pay their own taxes. They're not eligible for unemployment. They don't get workers' comp. There's no vacation. There's no withholdings. All of those sorts of things spelled out in that written contract is really going to be helpful if there's ever a scenario where there's a question about how that independent contractor is distinguished. Okay, let's move on and talk about kind of standard or boilerplate contracts. So these are kind of templates that you might find available. They're pre-written, and they can be helpful in business transactions, especially if you have the choice between having a template or having nothing at all. I would pick the template, right? They're designed to be generic. They're applicable in many different scenarios. You see them in service agreements. You see them in NDAs, those non-disclosure agreements, and they're definitely helpful because they save time and effort. They're often ready to use. You might be able to fill in some blanks. You can truly get a lot of time saved in putting them together. They tend to be very inexpensive and adaptable. And today, with artificial intelligence and the numerous tools out there, you can get templates to be pretty helpful to you. So I definitely encourage use of a contract in writing in whatever form over not having a contract without question. However, there are some downsides, right? A basic template is a basic template. It may not be unique enough to cover your needs. While it's efficient, it's not necessarily customized. You may not know that something important has been left out because it's just absent, right? It's missing. And so you don't know that it needs to be added because it's just not on your mind. Oftentimes, they're very neutral, right? Middle of the road. So it may not, a boilerplate contract might not have enough protections for you because it wasn't meant to be one-sided. It wasn't meant to be prepared for you. And so you could overlook some key potential risks or other opportunities that you would miss if you had a tailored example. Here's a good scenario. NDA templates. They're available, they're common, they're helpful, but they're generally very neutral, right? If you had something in your business you really needed to protect, like your kind of proprietary secrets, trade secrets, if they aren't specifically referenced in that NDA, that NDA may not be comprehensive enough to really protect you and your business. So get some customization in the critical parts where you need it. The last thing I'll mention is, if you were to use boilerplate contract for an employment agreement, then you want to take one step further and make sure you pay attention to a template that has local law considered. That you want to make sure your template considers, if you have obligations under the city of Pittsburgh law or the state of Pennsylvania statutes, because the last thing you want is to have a contract in place that as soon as you sign it, you're in breach of your obligations as an employer under those jurisdictions. Okay, so let's move on to now distinguishing with customized contract, right? This is where you can account for the really unique aspects of your business, specifically tailored to the needs that you have, specific to your requirements, specific to these parties, right? You and the party you're doing business with, because you're going to draft it to reflect this arrangement with detailed clauses, specific risks, specific obligations. The positives of doing it this way is it's going to ensure that everything that's in that contract is relevant, it's detailed, it's fully aligned with that particular business opportunity. It's going to account for specific goals. It's going to take into consideration your industry, right? Like if you're in the healthcare space, that contract is likely to be very different than a business not in the healthcare space, right? So a template may not be helpful. So all of these higher levels of protection that you get in a custom contract may be worth the effort, especially if it's one you get to reuse, right? You create that contract for customers the first time around, and then you can reuse it for customer B, C, D, and E, but at least you got a really good custom agreement in place. There are, of course, investments, right? You've got to put the time and energy and funds into creating that custom contract. So you might bring in legal expertise, which is going to cause that contract to be a little bit more expensive than using a standard one, because it's going to give you all of those extra perks and complexities that you get with that added legal guidance. It's possible if you don't guide your legal advisor well, you might get an overly complicated contract, or a contract that's not conducive to being friendly to the other party enough that they want to sign it, right? So definitely give guidance to when you're creating that custom contract to fit your business and the people you're doing business with. So let's say, for example, you're getting involved with a joint venture, right? Joint venture is a space that is strictly contract law, right? There's no statute to protect people in joint ventures. It's what you agree to, and every single joint venture is different. So you need that custom contract to address the very specifics. Who's making decisions? How are we going to share profits? What happens when the joint venture is ready to go your own way, right? How do you exit? And then what do you do with the assets left behind, especially if it's mutual property like patents or trademarks, right? So having that joint venture contract very specific to that opportunity would be a perfect example of why you would want something customized. Okay, let's talk about when you should have contracts on your radar, right? Entrepreneurs, we know now, benefit from prioritizing contracts throughout their business, throughout the whole journey, because you're managing risks every step of the way, you're clarifying your roles, you're protecting relationships. And so as your business grows and changes, what kind of contracts should be on your radar at any given time, right? So your business goes through kind of a developing life cycle over time, and what you're paying attention to at early in your business may be different as your business kind of develops. And so you want to adjust your complexity and sophistication with your contracts as your business changes. So maintaining relationships, who you're in business with, all of these sort of long-term changes can be really, you can be really proactive in managing the success of your business in each one of these phases. So let's talk about that. First phase would be, oops. There we go. That kind of inception or startup. We'll talk about kind of the mid range, which is development and growth, in a minute. And then we'll conclude with kind of established or very mature business as the third phase. But initial agreements, this we mentioned earlier. If you've got a fellow owner, partners, key investors, those that are in kind of investing in your enterprise from the very beginning at that startup, you want to have these co-owner and partnership agreements built as a foundation. This is when you're forming those relationships. This is when you need those clear expectations set to prevent misunderstandings as the business begins to take shape. So partnership agreements that identify who owns what your roles are, what your responsibilities are. Everybody cares about the finances, right? How will profits be shared? How will losses be shared? Having some clarity about what you do if you end up in some sort of dispute. Similarly, for investors, they're likely to be contributing dollars. How is that equity treated? When is it convertible? Is this a loan, or is this a piece of ownership? You would actually define those investment terms, set dollar values, decide valuation, expected return, anything that's critical to that investment relationship. Next, vendors and suppliers. We talked about this earlier about the value of having an understanding of those obligations. Because we're now in that the view of a startup or an early stage business, if that vendor is critical, such as essential software or a key manufacturer, you need that contract to be solid because you're building your whole enterprise on that relationship. So that's when you want to make sure you're really paying attention. Let's talk about the next phase, which is sort of that growth phase of your business, right? So you need your contracts perhaps to be a little bit more formal now than you might have seen in the startup phase, especially with your customers, your employees, the space that you're renting, the leases, because you're getting a little bit more intricate service, you're getting a little bit more deep into those relationships, and so a growing enterprise really does need to recognize that. So let's use the commercial lease as the first example, especially as you commit to long-term rental. Most commercial leases are 2, 3, likely 5 or more years. You want that the focus on that huge commitment to those funds of yours for over 5 years to be clearly articulated in a really strong contract. Employment agreements, right? Well drafted employment agreements are going to protect that relationship and all of the investments behind the scenes, all of the critical company data that employee gets access to. You can protect it in a good contract where your employee has to keep that information confidential and not use it in the market against you. Service agreements. We've discussed contracts with customers and vendors. We've also discussed NDAs. These are very, very common that you would see kind of in that growth phase of a business. But let's move on and talk about the third sort of element of, or I'm sorry, the third phase of as a business matures. And this is when you're pretty established, right? You've got good contracts of all of the basic nature for your fellow owners and your employees and your customers and your vendors. But now things are developing into more complex deals. Maybe you have an opportunity to acquire another business or merge or get involved into a joint venture or some sort of really critical expansion of your business. And these types of long-term commitments should be really well articulated in contracts, especially when you're dealing with large enterprises, major projects, licensing, or some sort of strategic alliance that you're kind of committing your future of your business on that sort of new opportunity. You want to make sure that you attend to the detail to protect that huge investment and the growth of your business. So mergers and acquisitions, detailed breakdown of exactly what you're buying, the risks that you might be acquiring. Maybe you're getting key talent or key intellectual property, The more detail, the better. So mature companies are likely to enter into these more complex contracts. And you're likely then to really be in a place to invest in the legal resources to make sure that you get those really sophisticated agreements in good form for you and your business. All right. Deborah was really, really helpful in pointing out to me the value of helping entrepreneurs sort of distinguish, those templates and those basic contracts we mentioned before. When should you go ahead and just download those or use AI to prepare something for you? Or when do you sort of shift the risk and protect yourself even further by taking that extra step to bring a lawyer in to work on a sophisticated contract for you. Um, in answer to that, I think every entrepreneur should understand basic contracts. I think you should have some access to some basic tools. And again, a contract is better than not having one, so I rest on that. But you also need to think about kind of when you get past sort of the convenience and the inexpensive template into recognizing that you have a complex or highly valuable or very specialized need where you want to make that investment because you're going to get the value out of it that you put as far as the investment into it, right? So good enough to download. I think NDAs, I think some simple service contracts. I think you can definitely work with having some of those kind of basic templates to help you. But when I think it pays off to consult with a lawyer, first of all, if you have a key contract that is going to be used again and again and again in your business, invest in it really smart the first time, and then you get to reuse it for your benefit. But other than kind of like a common or a regularly used contract, I would also point to any contract that would be related to high risk, right? If it has potentially egregious consequences, if it goes wrong, right? Potential ugliness. If it's highly financial, highly reputational, highly legal, you don't want to put those sorts of severe sort of value points at risk. If you have intellectual property, I would say is another one in this category, right? If you've got uh, patents at stake, your trademarks or copyrights, because there is a lot of complex law out there about enforcement and how one party can bring claims against another party for infringement or competition issues. So having someone who's sophisticated and understanding the complexity of that law is going to make sure that you not only are protected, but that you don't misstep, right? That you don't inadvertently do something in contradiction with what those federal statutes are. So those would be high risk. High value contracts, right? If it's a big part of your business, let's not put a big chunk of your enterprise at stake without properly protecting yourself. Investor agreements, I think that's just savvy to make sure that you're thinking wisely and get professional guidance when dealing with investors. I mentioned, the partners in the foundational kind of co-owner agreements early on. While things are smooth, get those all very finely hashed out and solid. The last category would be if you've got any sort of contracts that is connected to a dispute that's been resolved, right? Litigation, sort of concluding documents like settlement agreements or legal disputes that you've reached some conclusion on. You want to make sure that any sort of document directly tied to the resolution of a legal dispute is written by a lawyer as well. Okay.
I actually think because we're on limited time, I'm going to say you all have the handout. I shared it as a PDF. It's complicated. And I'm going to actually ask Marcy to skip over this. You can look at it, and if people want more explanation of any of them, you can ask in the Q&A, but she has about a dozen more slides I want her to have a chance to get through before we go to the Q&A. So I'm going to make that executive decision. It's complicated, but it's all in writing for you as well in as simple language as we could. So on to the common pitfalls, Marcy.
Common pitfalls, right? Let's highlight those things that frequently just go sideways and can lead to really significant legal and financial issues, right? So you can avoid these risks because we know now the value of having a very precise contract that's been thoroughly reviewed, properly documented, and you're going to be actively managing those contracts. So it's going to put you in the best position because you don't have ambiguous terms, right? You're going to avoid issues because you're going to make sure you have precise language. You avoid anything that's vague or could open up the door to different interpretations, unmet expectations, and avoid those costly legal disputes. So well-defined terms, I think, are essential. If you're going to get it in writing, get it clear, right? Make sure that everybody understands their part. If you've got, a reference to something industry specific, definitely spell that out, right? Avoiding terms, something like, here's a perfect example, something about a reasonable time frame. Well, you might think a reasonable time frame is 1 week. The other party might think a reasonable time frame is 2 months. Avoid it. Put the specifics in there. Agree on the precise time frame and add it, right? Using precise, straightforward language that clearly delineates is going to set those expectations very, very clear. Another example is I mentioned marketing contracts before because we all tend to encounter those in our entrepreneur lives. So social media contracts, they often refer to as quote unquote impressions, right? What is an impression? It can be anywhere from total views, unique views, served ads, ad blocked, bot traffic. I don't all of these various things that we shouldn't have to question, right? Impressions should be delineated to exactly what that is so everybody knows. The market company knows what they need to provide and perform, and you know exactly what you're getting for what you pay for. The next pitfall that I'll mention is because we wear so many hats as entrepreneur, because you're doing so much all at once, maybe you don't take enough time to read those contracts, and perhaps you're signing something that's not fully understood. So I think it can be a very costly mistake to sign an agreement if you don't fully understand its terms, or worse, you didn't even get the opportunity to read it, right? So I think an oversight like that can create unexpected obligations. It could restrict you. There could be financial consequences, all of which could have been avoided if you took a closer review. And the word of caution is that even a routine contract or what you would think is maybe a standard contract could possibly have some extra provisions in there that could significantly impact your rights and responsibilities that you just didn't get a chance to notice without good, clear attention. So make sure you get a full reading of all of those comprehensive terms. A common example I see is in commercial leases. Oftentimes, someone might think back to their days when they were renting an apartment as a residence, and you had all of these protections built in the law. Well, in commercial leases, tenants don't get those protections. If it's not in the commercial lease contract, you don't get it. So if you want to be able to sublet, it needs to be spelled out in that contract. You don't inherently get some rights that you might remember back from when you were just renting an apartment. So read every clause carefully, highlight things that are unclear, get specification, have a conversation, write those extra details in, if need be, get some legal help. The third pitfall is going back to the beginning of our dialogue together today is those contracts that you had via a spoken conversation that you want to rely on. If you don't get them written into a contract, while they could be binding, they're very difficult to prove if a dispute arises. So have a contract reduced to writing to make sure that you can use it in your business enterprise as you intended that agreement to be when you made it. The last pitfall here is oftentimes contracts have very precise language about what happens when that term, that duration is met. Does it terminate? Does it automatically renew? Do you have to take an action for it to renew? Do you have to take an action so that it doesn't renew? Whatever that case may be, if you don't pay close enough attention to termination and renewal provisions, you could be unintendedly committed longer, or you could lose some future that you had planned if you don't follow that, right? So proactive review and management of those clauses are going to be critical to maintain control, right? So find out exactly what those renewals and termination provisions are, calendar them, give yourself some advance notice, make sure that you're keeping track of expiration dates and notice periods, anything that might require you to be able to continue in that position contractually. Okay. Um, um, there we go. Oh, okay. So practical tips. I think we've captured a lot already. Let me just remind you that, templates or boilerplate contracts can be helpful, but I think, depending on the scenario, you might not want to just fill in the blanks. You might want to do some thoughtful planning and all of that attention to detail. But if you're really strategic from the beginning, contracts can help you. I see it as an opportunity to shift risk, right? Put in the contract what is ideal for you, shift all of the burden to the other side, shift the risks to the other side. You can actually really upside your position in a well-drafted contract in addition to protecting your interests.
I think the other thing that you're bringing to light here is that a contract is just supposed to get down in writing what your business agreement, what it is, what's the deal you're making with somebody else. And that's still just a business decision. So being very thoughtful and strategic about how you want that business relationship to work, this is just putting it into language that everyone can sign and agree to so you can proceed to do it. It doesn't travel on its own. It's just embodying the business agreement and decision that you've made. So it doesn't travel separately. It's one and the same. So here, let's go through the tips, and then I see some good questions popping up.
Great. Okay, so we're going to avoid overly technical terms, avoid complex legal language, like make it very clear, right? Avoid the jargon, clearly define the terms, use straightforward wording. Our whole goal here is to make sure everybody clearly understands, right? So preventing ambiguity which could result in disputes. We want to get away from it, right? So don't make a contract more complicated than it needs to be. It doesn't need to be difficult to read. Use clear terms and make sure it's simple so that everybody knows exactly what they need to do. I do think tailoring it to be specific is valuable. One size fits all isn't necessarily going to get you where you need to be. So when the time is right, invest in customization or adapt a template to meet your needs, right? Add extra language to protect you for local laws or regulatory guidelines, whatever the uniqueness is, go ahead and get it in there. If customizing your contract is available to you, also don't make it overly complicated, right? So I say this because somebody might cut and paste a couple contracts together to make one fit for their current needs. But copying and pasting without proper application can sometimes do more harm than good. So be clear about what you're trying to accomplish and precise about it. Including essential terms, absolutely, right? This is one of our primary goals, is to make to avoid the risks and to make very clear what each party is committing to, right? So defining the scope, define the deliverables, define the timelines, define the payment terms, make clear the termination clauses. If you need things kept confidential, make that very express. If you don't want the party competing, make a non-solicitation clause part of the contract. And then I do recommend, what do you do if there's a dispute? Have that spelled out, especially if you don't want to. Going to court is the default. You don't want to go to court. Talk about mediation, talk about arbitration, whatever is ideal for you, those parties, and that scenario going forward. Seeking professional advice, right? If it is a high stakes contract, If you are really looking at something incredibly impactful to your business, then investing in professional services will pay off in the long run. It'll save you some time, some money, definitely some legal trouble, and it'll give you peace of mind. Right when you're in doubt, consult with an expert who is going to help you get something legally sound and enforceable. This adage applies in many areas of life. It certainly fits here, right? If you spend a little extra time and money on the professional advice early on, it might help you avoid bigger costs and problems later. So think about those saved expensive mistakes when appropriate. And that concludes all of my prepared slides. I am happy to answer any questions that you all may have.